So we talked before about the methods of voluntary alienation. One of the methods of title transfer, okay? A grantor has decided and agreed to sell or grant their property. Our next section, where we start on page bottom of 95 and on 96, are going to be involuntary alienation, which is the grantor does not necessarily authorize the sale, but it happens anyway, okay? Involuntary alienation usually occurs by in a foreclosure auction or condemnation for eminent domain. On the top of page 96, it's got a really great chart as to the 4 processes of involuntary alienation, and the terms that you're going to want to really familiarize with are the process, the ones in the middle. Okay? Those are the 4 forms of involuntary alienation. The first one is my favorite because it's easy to remember. It's cheat. Cheat is when a person dies intestate, and intestate is a fancy way of saying the person died without a will. They own property, they don't have a will, they pass away, and they leave no heirs. No kids, no living relatives, nobody to leave their property to. The state will take it back by the power of its cheat. So in essence, the state cheats their way back into ownership of that property. Like, oh, sorry, you passed away without a will and without any living heirs. We'll take that back. Thank you. Okay, so you'll see that occur. The next process is a little bit more kind of involved and lengthy. Eminent domain. Eminent domain is simply the right of the government to acquire privately owned property for public use. Okay? So eminent domain is the process, and the way that eminent domain occurs is through condemnation. Condemnation is the government exercising their right to take private property for public use. You might see that occur, and we have seen it occur, when they're building new highways, changing road structures. Eminent domain sure occurred when they were changing Gate City Boulevard and or High Point Road, for those of you who've been here for a long time, and they rerouted it, and they took the front strip of a lot of businesses up there, and they rerouted it. They renamed it Gate City Boulevard, and they, in essence, used those commercial private properties for their highway construction or for their road construction. In North Carolina, a property owner must be compensated for that. So the government does have the right to say, hey, we want to use a piece or all of your property. This is how much we're going to give you. So in North Carolina, it doesn't matter how destroyed the property is. If there is an owner on record, the government has to do what they can to seek that owner out and justly compensate them for taking their private property for public use. Okay? And if you look in the middle of that paragraph, it reinforces what I just said, saying just compensation is to be paid by the owner. So I'm in the middle of that eminent domain paragraph. And the rights of the property are protected by the law. Go to the bottom of that paragraph and notice where it says here, if the taken property is leased, then the tenant gets entitled to the compensation for the damages. Eminent domain typically does not occur on a national level. So much like zoning, eminent domain is very local in nature. It will occur within a city, within a municipality. You're not going to see the federal government come to your neighborhood and say, you know, we're going to take this piece of property for our highway building. Okay, it's delegated to the individual cities and states. So the beginning of that last paragraph on the bottom of 96, that's what they're saying. Basically that the power of eminent domain is delegated to cities and counties. On the top of page 97, they talk about a court case that occurred where eminent domain became a hot topic. The case called Kelo versus the City of New London. And there was basically a disagreement between a private owner and the city about the government's right to take that property without compensating for public use. So if you kind of go skim down to the middle where in North Carolina is in the margin. In North Carolina, our General Assembly reacted to that decision by saying that eminent domain can only be used to take a blighted parcel, and that still, it must be justly compensated to the owner. Blighted means that's like it's ruined or it's wrecked or something like that. Now, one of the next way that property can be involuntarily alienated would be lien foreclosure. That second to last sentence, debts that could be foreclosed include mortgage loans, real estate taxes, mechanics liens. Do you know what a mechanics liens is? Have you talked about those yet? Okay, so basically contractor did work on a property and never got paid, and they go to the courthouse and they record that lien. You see lien foreclosure a lot, and you saw it a lot more during our market crash in 2007 and 8. People just couldn't afford their homes anymore, so they just stopped paying their mortgages or their taxes, and they got foreclosed on. So they're not as common, but they're still out there. And I have also seen, side note, I have also seen a lack of payment to an HOA result in a foreclosure. So you never, if an HOA is not doing their part in a community, you never want to tell the owner, like, oh, just stop paying your fees or whatever like that. Because not paying the HOA fees, I have seen result in foreclosure. Okay? So the last way that property can be involuntarily alienated is adverse possession. Adverse possession is basically a person making a claim of ownership saying they have a reason to believe that the land is theirs. On the bottom of page 97, look how it says, owners who do not use or inspect their land for a number of years may lose title to another person who makes a claim to the land, and more importantly is using that land without the owner's permission. On the top of page 98, it gives us this acronym for the criteria that make adverse possession possible. I think, and before we go into this, I think often of, I read somewhere online that Dan Aykroyd purchased an island off of this was probably like in the 90s. He purchased an island off the coast of Alaska. He bought his whole own island. And then he goes back there, a couple times a year, and he used to take his family camping and blah, blah, blah. And I used to wonder to myself, what if he went there and found like all these people who had built houses on this property? Or what if he came back one day and found, a whole tribe has taken over his island? What would he do? You know what I mean? But if he didn't go to his island for so many years, he could potentially lose title because of these 5 criteria on the top of page 98. The other person's use, the claimant, as they're calling it, must be using the property openly. Okay?
Under adverse possession,
Yeah.
is that the same thing as squatters' rights?
Squatters' rights? I have not, what are squatters' rights?
You squat, it's not yours.
Well, squatters' rights squatters only have rights based on the fact that eviction takes at least 60 or 90 days to complete. So I don't know if squatters' rights is like a legal term or like a legal thing in North Carolina, or if that's kind of a, like a neighborhood maid kind of phrase. We do not use squatters' rights as a term or a concept when we're practicing real estate, because really their only rights are to stay there until they're forced to leave. Because in order...
Wouldn't that be similar to adverse possession?
No, I wouldn't try to correlate those two because they're not really related. The only reason squatters have rights are because a landlord cannot physically come and fight a person to get out of a house. They have to take legal action. So that gives a squatter a right to squat until, the court allows the landlord to do something. So adverse possession is more like, I own 5 acres of lot next to your 5 acres, but I put my fence up 100 feet onto your property, and you never walk your full 5 acres, so you don't know that I've got my fence up on your property, and you never really notice it. Nobody ever notices. So it's open. It's continuous, which means you never came and tore my fence down. Okay? It's exclusive, which means I'm not sharing it with you. I'm just saying, this is my property, this is my fence, this is, my stuff. It must be adverse to the possession, so meaning I have to put my fence up on someone else's land, so it's not my land, I just put my fence up there and I'm calling it mine. And the most important thing I think that differentiates is that it must be without the permission of the owner. So, for example, I never get permission to put my fence up there, I just do it. Nobody ever catches me, and my fence stands.
But couldn't I do the same thing if you had an empty house and I just moved in and took possession of it and you never checked on it?
Well, so a person could certainly lose title if they never checked on their house or they never checked on their property. They could lose title, but we don't really use the term squatting when we talk about adverse possession, because squatting refers to the kind of the unauthorized use of a property that is not legal. You can't legally acquire a property by squatting.
Well, in North Carolina, we don't have squatters' rights. That's probably why we don't hear the term.
Mm-hmm.
But, what I'm just asking is adverse possession the same thing?
Uh,
Because from what you're describing, it sounds like it is.
Yeah, and in other states, maybe it is, but in North Carolina, we do not recognize any rights of squatters because they're not true owners. Adverse possession is, I'm legally trying to take possession of your property. I'm legally trying to. So I'm putting my fence up, or I'm moving in your house while you're not there and you never catch me, but 20 years has to go by.
How would you consider that legally?
By these 5 criteria that the book gives us. It's open, it's continuous, it's without permission of the owner, So, kind of like at the beginning, I'm coming to your question, kind of like the last sentence on the bottom of page 97, read that. Owners who do not use or inspect their land for a number of years may lose title to another person who makes a claim and wants to take possession. Squatters aren't typically going to have the money to go to court and be like, yeah, I'm taking this. Because it's a pretty costly procedure as well. What was your question?
Now, I think Jen said this yesterday, but I forgot. If you do that, and then a new owner comes in, and you've been on the property for 20 years, does the new owner coming in change anything up, or can you still claim on that land?
So if the property is sold, so that's a good question. Now, in practical, or hypothetically speaking, I suppose a new owner could come in and make their own rules. In practical purposes, nobody is buying property without inspecting it anymore. Nobody's buying property without going to the actual property to visually see it, make sure it's there, make sure it's still standing before the closing. Make sure that the house hasn't been burned down the day before closing. So hypothetically speaking, and for purposes of the test, I don't try not to delve too deep into those rabbit holes, because what the test wants you to know is the 5 criteria that make the possession adverse and the period of time that that possession has to take place. For example, I sold a property in Winston-Salem, and my buyers decided I was representing the buyer, they decided they wanted to do a property survey. They did a property survey and discovered that the house next to them had built a brick wall that was like 15 feet encroaching on their property. So they asked the attorney what they should do, and the attorney said, well, you can do a couple of things, but you could ask them to take it down, because now you know it's on your property. You know that they have constructed something on your property. Or you can give them permission to use your property for their brick wall, and then they can never adversely possess your property. So my neighbor, my client, the buyer, sent their new neighbor a copy of the property survey, certified mail, and said, hey, we're so excited to be your new neighbors. By the way, we know that your brick wall is partially on our property, and we're okay with it. Now that they've given permission to the neighbor can't ever try to claim that portion of property as their own. So once you give permission to somebody, it takes away the whole, and you keep evidence of that permission, it takes away their ability to file the action to quiet title, which is a term you're going to want to know. And you go down to that paragraph on page 98, the third one down. Action to quiet title is the adverse possessor going to court saying that that property is theirs and they should be the legal owner. By the way, property owned by the government can never be subject to adverse possession. So if you live on a property that's bordering a park or a national park or something like that, you can't build your fence 20 feet in. Even if the government never comes and tells you to take that fence down, you can't ever file action to quiet title against the government. Okay? So now we're going to talk about the transfer of deceased person's property. We talked a little bit about that before. When a person passes away, intestate. Intestate succession is much like dying intestate without a will. Intestate succession says he died without a will, and now all of your successors are going to get the property, or the court is going to, in essence, make a will for anyone who did not do so. So if you look in the middle of that paragraph there, in effect, the state makes a will for anyone who didn't do so. And that's with heirs. Okay, succession implies that there are successors. There are heirs. Okay? I had a deal I was working on, and this lady had acquired property before she got married, and then when she got married, she never had her survivorship. They never had survivorship rights amended to their deed. When her husband passed away, his kids inherited his interest instead of just her. So if they had done joint tenancy, she would have inherited all the rights, right? But they didn't amend the deed, so when he passed away, his interest went to his heirs instead of her, and because he died without a will, they had to go through this long probate process to determine who are his heirs. They're minors, now they need guardians. So because he had ownership interest in a property that did not have survivorship rights, died without a will, intestate succession takes place. I lost that deal, by the way, because the buyer couldn't wait 90 or 120 more days for that whole process to occur, because that process takes a while. So that's one way a deceased person's property can be transferred. Transfer of title by will. A will is a written instrument, as we all know. It usually has the division of assets or something included in it. And what's important for you to know about a will is that ownership, and I'm reading this phrase straight out of the book, ownership interests such as joint tenancy or tenancy by the entirety cannot be, cannot be affected by the will. So what that means is you cannot disinherit your spouse. You cannot will them out. If you're legally married, your spouse has interest in everything you own. So it even says it again at the bottom of that paragraph. Neither spouse can disinherit the other. North Carolina Intestate Succession Act. Okay, so you see this word intestate again. And basically it's just saying that a person who passes away without a valid will, North Carolina will create a will for that person and allow for the equal division of property among eligible heirs. Okay, at the top of page 99, it just really kind of breaks that process down really simply and says, the state is going to divide your property if you don't, and if there are no living heirs that can be found, guess what? The state of North Carolina takes your property back. Buy it is cheap, right? The state says, great, more for us. Okay, so now we are going to, now that we've talked about that, we kind of have an idea of why the title and the title search and all of that is so important. Go to page 99 here on the right-hand column. Title and public records. This is just giving you a breakdown of where title records are kept, where public records are kept, and who maintains them. So whenever I have a question about a public record, maybe I want to know if a street is publicly or privately maintained. Maybe I want to find a deed that I can't find somewhere. We used to have to go to the courthouse, but now we can look online or we can call somebody. Okay? So that's a real benefit now, because I think before agents really used to have to go to the courthouse for everything. Most of this stuff's available to us online now. We spoke earlier about recording and how recording is the act of placing the documents in public record. We're recording to give constructive notice, right? whether it's a deed or a lien or a plat map or a septic permit, it's giving constructive notice. It's making it public record. When people get behind on their taxes, that's a lien that gets recorded and it's public record, right? Right. So turn now your books to page 100. And in North Carolina, we're what's called a pure race state, which means the first person to go record their lien is the first person that gets paid when a sale occurs. There is one lien that takes priority over all other liens, no matter whose is recorded first. And can anyone guess which one that would be? Yeah, property tax. Because it doesn't matter if D.H. Griffin records a mechanic lien and American Express records a judgment that's a lien attached to a property. Uncle Sam is always going to get his money first out of the sale of a property. And in North Carolina, they call that they call us a pure race state, meaning a race to the courthouse. Whoever records first really does prevail. That also applies to the sale of a property by the same token. So, for example, before we recorded deeds publicly to give notice, you could have seen scenarios where I sell my property to one person and that person doesn't ever give constructive notice. They never make their sale public. And I find that out and I'm like, huh. So I sell my property again and tell me your name again? Linda. Linda records her deed. And what's your
Jason.
Jason, that's right. Jason doesn't record his deed, but I sold it to Jason first. Linda records, so in the eyes of the law, Linda actually has ownership and title to the property, even though I sold it to Jason first. Could I be sued? Yes. I probably will be. But he who records first will prevail in the eyes of the law, whether it's a lien or title. So that's just another one of the many reasons why we record our deeds here in North Carolina, because it really protects the buyer and the seller.
So you took money from Jason and myself for that one piece of
For the
property?
same piece of property. So, right, and because of he who records first prevails, we are that kind of state. They call that a pure race state. So in a state where whoever races to the courthouse first and records, they win in essence. So when you see the term pure race state, which I know you will later in the text and maybe even on the test, that's what that's referring to. Now, going to the top of page 101, okay, we're going to talk a little bit about chain of title. We've talked about title insurance a little bit. We touched on it. We talked about the deed and deed recordation. The chain of title is the record of a property's ownership. So that is when the attorney is performing a title search, they're researching the chain of title. They're researching every time that deed has transferred hands. It went from you to you to you to you to me. Okay? So the chain of title is merely the record of the property's ownership. And going 2 paragraphs down, where the VIP is in the margin, if ownership cannot be traced or there's a gap. So let's say it looks like the property kind of floated in thin air for 6 months or for 6 years, an attorney has to take court action to establish that, and they call that suit to quiet title. So we have a lot of different terms and phrases in this chapter that are like suit to quiet title, action to quiet title, cloud on the title. My recommendation to you all is to get, I like the oversized index cards, but take every phrase that has the term title in it, put them in one place, and define them, and get to know the difference between them. Because you might see a test question that says, Sue is trying to take adverse possession of Bob's property. What is she going to file? And you might see, your answers might be A, cloud on title, B, suit to quiet title, C, cloud on the title, or B, D, action to quiet title. So your questions are going to be structured when it comes to knowing all these different phrases. They're going to be structured kind of like that, where they want you to be able to pick out the right one, but they're going to give them all to you in one thing to try to confuse you. So a suit to quiet title would be the attorney trying to, or the court action that tries to establish ownership. Attorneys wear suits, and that's a suit to quiet title, and that's kind of how I remembered that one. But you might find a way that works better for you. Now, in the next section, title assurance, we're going to talk about marketable title and title insurance, and we'll touch on title recordation again. Marketable title has 5 criteria that are basically the same exact criteria as the covenants of a general warranty deed. So in your margin, you can actually put page 86 and know that these 5 criteria for a title to be marketable are directly related to the 5 warranties of a general warranty deed. Some of them even have a similar language, but for a title to be marketable, it can't be in court for anything. It has to be able to be turned around and sold or mortgaged. So these 5 criteria directly relate to what we talked about on page 86 with the general warranty deed. And in the bottom of that next paragraph, see how it says a buyer should insist on a title search and a property survey to make sure they're getting marketable title. So in some transactions, like when a buyer is paying cash, it is optional. It's not optional when they're getting a loan, but paying cash, it is. And in the case of my friend who became my client later, he paid cash for a property, didn't get the title search, and inherited a $5,000 tax lien. How unpleasant is that to discover? So as brokers, we, especially with all the information available online, we can look up property all day. Sure, it's public record if this seller is in bankruptcy or they're behind on their taxes, but we don't get to do a title search or give an opinion of title. So a buyer should always insist on a title search to make sure they're getting what they paid for. Because the last thing you want at the last minute is for something to come up 3 days before closing, and you think you're about to be getting paid, and then you find out, boy, you're not. Because something's wrong with the title. So a title search is the attorney researching the chain of title and the attorney's examination of all the public records of the title. If you turn your books to page 102 and highlight that last sentence of that paragraph, real estate brokers, not only do we not, we are prohibited from giving an opinion of title. We're prohibited. It's out of our scope of expertise. I have had a client before who was purchasing a property that the seller was in bankruptcy and had been for a number of years. So all of her stuff was public record, and it was just, you could easily see when you Googled the name and the address that this person was in bankruptcy. And he was so worrisome, and he was so concerned, and he was like, Yasmin, do you really think I'm going to be able to get this house? This property owner is in bankruptcy. They owe this to this, this money to that person, and they're in bankruptcy here. And I could see all the same stuff he did, and he would forward me the links. But not only can I not interpret what I'm seeing because I'm not an attorney, I'm prohibited from saying, oh, you know what, we really might not be able to get that property, let's move on. Because the fact is, when it came down to it, he was able to purchase that property. And the sale did go through. Because even sellers in bankruptcy can sell their property in a court-approved sale. So, when it comes to the condition of a title, I always say leave that to the experts. Let the attorneys do what they are getting paid to do. Okay? Which is research the title. The report that is the attorney's report and opinion of title is called an abstract of title. And that's in the middle of the second paragraph. The abstract of title, aka the condensed history of the title, the attorney's findings on the title, they call that an abstract of title. It's a very legal term. We use abstract, we think of, art or something like that. But in legal terms, they call that report the abstract of title. And furthermore, it says, let's see, so most attorneys, so go a little further down to Marketable Title Act. Most attorneys agree, and we do have a state legislation, the Marketable Title Act, if the property has a title that can be traced for 30 years without a defect, it is considered marketable title. They might search further back if they can, but in North Carolina, we have the state legislation, the Marketable Title Act, that says if you trace it back for 30 years and it's good, it's good. Now, to alleviate any things that could come up, buyers should always have title insurance. We talked a little bit, and I pointed out, like on page 103, all kind of the different things that title insurance can protect the purchaser from. But the title insurance is really only issued once the title has been searched. So you can't have title insurance if you haven't had a title search done. So sometimes a buyer might ask you, can I forego one or the other? And of course you always want to advise them that that's not a good idea. Title insurance is a one-time fee paid at closing, so you'll want to write that down in the margin because you may see that somewhere, and that will actually come up again when we start talking about settlement of a transaction. But title insurance is not like other insurances that you pay every month, mortgage insurance and property insurance. I wanted to keep saying assurance, I'm sorry. Title insurance is a one-time paid at closing. On the bottom of page 103, it describes, so the first VIP tells us it's paid for once at closing, and the second one gives the kind of the breakdown of how the insured owner is compensated. Title company will pay the owner the value of the property up to the face amount of the policy, which can vary depending on title insurances. Again, that's something the attorney is the expert on, because in North Carolina, so if you turn to page 104, we are what's called an approved attorney state, which means the attorney is the one who does the opinion of the title, not the broker. So, by the same token, when my client kept asking me what I thought of that house, that the seller was in bankruptcy and did I think he would actually get the house, I'm not really able to give him a real opinion of title because number one, I don't have all the facts, and number two, because we're an approved attorney state, so the attorney is the one who gives the opinion of title, not the broker. In the middle of that paragraph, it reinforces what we said earlier. Based on the preliminary opinion of the title, then the title insurance company will say, okay, great, thank you for doing that title search. Now we're going to give you title insurance. Okay, so they'll never insure a buyer, they'll never insure the title if it hasn't been searched. Okay? So going on, we talked quite a bit about title recordation, but on page 105 in the middle, it goes on to reinforce what we talked about earlier, saying that the title recordation gives constructive notice or legal notice. And then in the book, they tell us that once you actually move into the house, they call that actual notice. Okay? You'll hear the term constructive notice used a lot more than actual notice. I think when it comes to recordation, it's important to know the term, some of the terms we've talked about already, like the Connor Act, North Carolina being a pure race state, which is described here. If you look in page 105 on that fifth paragraph down, the last sentence, because North Carolina is a pure race state, recording gives legal priority to those interests that are recorded first. So I know I said that earlier, but I like to point out in the book where it says it, because sometimes I'm jumping ahead of myself or saying things on one page that are actually mentioned on later pages. So I try to point out what I said. The next paragraph, we talked about the Connor Act. The Connor Act is a state law. This is not a national law. Y'all, this is a state law that says, in North Carolina, we're going to record every deed, and that's what constitutes as delivery and acceptance. Delivery and acceptance being that last element of the deed to be valid. Our state legislation says we record, okay? Notice how it says, under the Connor Act, this is in the middle of the paragraph, if a purchaser fails to record a deed but a subsequent purchaser does, the subsequent purchaser's title takes precedence over the first purchaser's title. And this kind of recording statute is called a pure race statute, meaning whoever records first prevails. The for example gives the example that I gave earlier. And talking about title insurance being a one-time fee paid at closing, look at the bottom of page 106 and you'll see the term excise tax. North Carolina excise tax, there's a few things you're going to want to remember when it comes to that. Number one is that it is all a seller and paid expense at closing, so write that down in your margin, because it is not a buyer expense, it's a seller expense. It is paid at closing. And the formula for excise tax is the sales price divided by 500. The other important thing to know is that in North Carolina, they don't want our coins. So if a property is sold for $289,250, the state of North Carolina says, please go ahead and round that up to the nearest 500. So what would be the excise tax here? $5.79, right? So when you're taking the test, somebody do the 289,250 divided by 500 for me.
578.5.
578.5. So if you're on the test and you forget to round up to the nearest 500 and you get something $570.50, remember, y'all, that the state of North Carolina does not want our change and they want us to round up. Because I promise you, if they give you a test question and says calculate the excise tax on this sales price, they're going to give you $578.50 as an answer option. Because when you divide it by 500, that's what you get. But they want you to know that the state asks us to round up. Because the state doesn't care about our change. Say, give me the next dollar. And this is your formula for excise tax every time. Okay? And you will very likely see a test question on that. So, just to kind of review what we've talked about in Unit 5, we talked about general warranty, we talked about the kinds of deeds we use in North Carolina, what makes them valid, why we record. We talked about the title search, who does it, why it's so important. Are there any questions about some of the topics that we've covered in Unit 5 so far?